Mr. Wagner.
My client is the South African Riding for the Disabled Association, and my brief is to represent them, but I also, through them, represent the entire disabled community of South Africa, and particularly in Cape Town. The disabled community are amongst the most vulnerable of our community, and an injury to SADA, as far as its constitutional rights are concerned, are an injury to the disabled community of South Africa. What SADA does is sketched out briefly in the home page of its website, which I think is at page 152 of the record. But what I'd like the court to be aware of is that SADA it's a non-profit organization with only a few permanent staff. Most of the actual work is done by trained instructors and volunteers. And they don't receive any remuneration. It's basically what they do is what they call equine therapy, and there's a psychological bond between humans and horses, and people suffering from mental disabilities. It's been proven that helps them, and that SADA does. And it's going on 52 years. The founder was a woman called Belinda Sampson, and she started SADA in 1973. Since 1980, SADA has been on the land where they are presently. The work they do is mainly, there are 15 schools that send buses with school children to the site in Brommersvlei Road. And these children are then given riding lessons, and this has been going on, as I say, for 52 years. One of the important pieces of evidence or documents in the record is a letter from the then Minister of Transport in the Western Cape, Robin Carlyle, to Belinda Sampson. It's dated July 2011. And in that letter, he notes the wonderful work that SADA does, and it's a discussion around an undertaking by him to give SADA a 50-year lease over the property that they had at that stage been occupying in 2011 for 20 years. The case for SADA is that in the process of awarding alternative state land under Section 35(1) of the Restitution of Land Rights Act, they were not, the argument is that the selection of Earth 142, which is the largest piece of the property which they occupy, that selection process was an administrative, in essence, an administrative process in which SADA's rights were totally disregarded. Its rights in terms of Section 33, just administrative action, and that infringement spills over or overlaps to a certain extent with the infringements of its Section 34 rights, right to open and fair hearing. The case has got a long history. It started, the application by SADA for rescission was launched in 2014. And it's been, the list has been examined by a number of courts, including this one in 2017. But my submission to the court is that there's a fundamental dynamic that has been missed, and I say this with respect, by all the courts, including this one. And that is that the Restitution of Land Rights Act, the regime, the scheme, is that compensation is awarded through lineal descent. The rules are set out very clearly. Only direct descent, people who have lodged claims and who have died, their direct descendants can claim. That's the one aspect. The other aspect is that in the scheme of things, there are 5 separate claims. The property, the dispossessed property, which is not the one that SADA occupies. The dispossessed property was owned by 5 brothers. The fact that they're brothers is incidental. It was owned by 5 people. They each had an undivided 5th share to that property. So when one applies Section 2(1) of the Restitution Act, if one of the brothers had 1 child and the other brother had 10 children, you weren't going to take the 2/5 shares and add 11 and divide it by 11. The brother who only had 1 descendant, that descendant would get the entire 1/5. The brother who had 10 children, his 5th would be divided amongst the 10 siblings. That's how the Restitution Act works. Now, historically, this property was owned by a single person. So I think his name is Daud Sadin. But he sold it. He sold it to the 5 brothers who are the source and origin of the claim before the court. But it's of fundamental importance to recognize that the Land Court judgment in 2012 awarded alternative state land, the equivalent, or even more than the equivalent of the dispossessed land, to a single individual who is actually only entitled to 1/5. That is an essential dynamic that cannot be ignored, and it can't be, for want of a better word, swept under the carpet. This is not a family claim for the property that Daud Sadin owned before he sold it to the 5 brothers. Now, that is one of the themes in SADA's case, is the theme of legality. The Constitution has the rule of law as a founding value, and legality has come up in innumerable cases. But legality is a key factor in this case. The most difficult point that SADA has here is this court's judgment of 2017. Because this court held that SADA was entitled to intervene, but that its right was limited to claim compensation. Now, the difficulty that SADA has with this court's judgment with respect is that this court ignored its own rules. The case to this court came by way of an application for leave to appeal by SADA from the Supreme, they applied for leave to appeal to the Supreme Court of Appeal, and then to this court. During the course of waiting for directions from the court, the Chief Justice sent out a directive that the parties file written argument on one particular point only, and that is the real and substantial interest that the applicant may have, i.e. its locus standi. That was all. It came as a complete surprise to, I think, all the parties when this court handed down a judgment deciding the actual appeal without the record. So the appeal was decided without the record and without oral argument. Now, Rule 19 says that applications for leave to appeal can be combined with hearings on the merits. But then Rule 20 applies, and then the court calls for a record. It's hard to say it, but this court itself infringed SADA Section 34 rights to a fair trial.
Just repeat that. You said this court did what to the Section 34 rights? Sorry.
Infringed SADA Section 34 rights to a fair trial, open and fair trial, and it's interesting to look at Erasmus's commentary on what happened here. The Chief Justice dispensed with oral argument, and the rules don't give the Chief Justice the authority to dispense with the record, but just forgetting about that for the moment, just concentrating on the question of oral argument. So Rule 13 of this court gives the Chief Justice the power to dispense with oral argument, and the commentators in Erasmus say that's fine if it's just an application for leave to appeal. But once it comes to an appeal, then different considerations apply. And if I can read from Erasmus, while the advantages of an expedited procedure in applications for leave to appeal or applications for direct access are readily apparent, it is submitted that for the following reasons, the power conferred on the Chief Justice to dispense with oral argument in other matters should be very sparingly exercised. The principle that a litigant is entitled either himself or through a representative to present oral argument in open court is firmly entrenched in South African law. In fact, failure to afford a litigant an opportunity to present oral argument may constitute a fatal irregularity. Oral argument can be more effective than written submissions, and neither the court nor the litigant should normally be deprived of the benefit of oral argument. The court, or a member thereof, may have a wrong impression of a party's case, as set out in the heads of argument, or have an incorrect view of the case. In both instances, the misapprehension may be remedied by appropriate oral submissions. Too ready exercise of the discretion to limit oral argument may create a perception that the court operates behind closed doors and that its proceedings are in some way secretive. It is a fundamental principle of our law, entrenched inter alia in Section 32 of the Superior Courts Act, that all proceedings in any court of law shall, except insofar as the court may in special circumstances otherwise direct, be carried on in open court. The underlying principle is that a court of law, as an organ of state, serves the public weal. And then it goes on to say, the right of access to courts in Section 34 guarantees the right to a fair public hearing before a court. Now,
Where did you read now?
it's a commentary of Erasmus.
Oh, the passage, please. I know it's Erasmus. Where in Erasmus?
It's the commentary on Rule 13.
Yeah, what page? Give us the reference, please, Mr. Wagner. Erasmus is a...
Justice, I used the electronic copy, and it doesn't actually, the legend at the top says RS4, and that's a revision service, 2024 B1 to 44.
Thank you.
So when it comes to what SADA's case is that, unhappy as it was with the direction from this court that it was limited to compensation, because it raised, in its written argument, it raised the question of legitimate expectation. It went along with the mediation process. And during the mediation process, it became apparent that there was a conflict between the seventh respondent, who's not here, and the rest of the greater Sardine family. And that led eventually in 2024 to an application by the family to substitute the seventh respondent, who had clear rights in terms of the judgment of Mshe AJ, to substitute the family represented by 5 family trusts. And the SADA's argument is that that application reopened the question of the right of the seventh respondent. Because the right of the seventh respondent was limited to 1/5 of the dispossessed land. And here we had an entire family wanting to be substituted for a single individual who didn't have no right to the entire property, but only 1/5. And that new application was one which then the court was then asked had to decide that issue, which was never before this court in 2017. And SADA's argument is that in that dispute, it could then again raise the fact that it did have locus standi to challenge the selection of the alternative land, the selection of its property in place of other properties. So even if this court's judgment was binding on the land court, it's not binding on this court. But the argument goes further than that. The argument is that because standing is a procedural matter, that it's an interlocutory, it's something that depends on the facts. And the facts in 2024, when the 5 families or the 5 trusts sought to intervene, were different. And before I go further on that point, just to go back to the failure of, with respect this court to grant SADA proper rights in terms of Section 34. If one looks at that judgment of 2017, almost every line has a mistake in it. There's almost nothing in that judgment there's some principles that are set out correctly with respect. But one of the major mistakes is found in paragraph 5. The claim for restoration was determined by the Land Claims Court in December 2012. The court ordered the transfer of Earth 1783, Constantia, to Mr. Sadiq Sardine, who is now the 7th respondent, a descendant of Mr. Omar Sardine, who is the owner of the dispossessed land. Now, Mr. Omar Sardine owned a 1/5 undivided share of the dispossessed land. He was not the owner of the land. The entire judgment talks about 2 persons, Ibrahim Sardine and Sadiq Sardine. It refers to them as the Sardines, with no real appreciation of the difference between the two. Ibrahim Sardine has now passed away, and he had no, the land court gave him no rights. He wasn't a player in this whole situation. He played no role at all. Another important point is, it says in paragraph 16, here it is common cause that the association was a lawful occupier of F142 at the time the variation order was made. It was never common cause. The state to this day disputes that SADA is a lawful occupier. That's apparent from its papers before this court and also from its plea in the pleadings in the Land Court. It makes no bones about the fact that it says SADA has no right at all to this land. So that is the prejudice suffered by SADA in the sense that possibly a substantive point was decided against it without the benefit of a record and without the benefit of oral argument. But to go back to the mediation, it became apparent, as I said, and which the conflict became apparent, and this then led to this new application. And the Land Court dismissed the idea out of hand. But either if this court's judgment in 2017 was interlocutory, then the Land Court could depart from it. If it was final, and if it was final, I mean, this court has the right to depart from it. But the point that may cause some difficulty is that the first respondent, the state, has raised the point about res judicata. Now, res judicata can only apply when the same parties are involved. Yeah, different parties were involved. Before it was only the seventh respondent and the applicant. Now it was 300 other people, 300 and up other people. And the issue before the court, the issue before the Land Court was the nature of the seventh respondent's right to the land. And there's a case which I didn't refer to in my written argument, but which I think is well known. It's the matter of Sunny versus, it's a judgment by Gildenhuys J, if I could just get the reference. It's in Ray former Highlands residents, Sunny and others versus the Department of Land Affairs. In that case, the Land Court makes it very clear that, makes 2 points very clear. That one, that compensation in terms of the Land Restitution Act is based on lineal descent. And it also makes it clear that descendants who have not lodged claims, as we have here, only one claim was recognized by the Land Court. The claim of Omar Sadin, or not Omar Sadin, rather his son, Mohammed Rashad Sadin. But this case makes it very clear that descendants who have not lodged claims are not entitled to compensation. It also makes it very clear that the compensation is distributed along lines of descent. And that's the point I made earlier. If there are 10 siblings, they share that 1/5 or whatever it is. That brings me to my next point about the selection process. Now, Section 35 of the Restitution Act says the court may order, Section 35(1)(a), the restoration of land a portion of land or any right in land in respect of which the claim or any other claim is made to the claimant, or award any land, a portion of or a right in land to the claimant in full and in partial settlement of the claim, and where necessary, the prior acquisition or expropriation. In B it says, it may order the state to grant the claimant an appropriate right in alternative state-owned land, and where necessary, order the state to designate it. Now, what we have here is what the land court, against the wishes of the parties before it, on its own, must have made inquiries about alternative state land. And what the land, and if we look at the wording of the section, the operative word is designate, which means choose. The land court itself went and selected a piece of land, Earth 1783. And it then changed to 142. But the point that I wish to make is that this selection of land, alternative state land, is an administrative function. Urban land is highly regulated. For instance, Earth 142 is zone CO1, community. You can't use it for residential purposes. But all those factors were not taken into account by the court, and the only criterion that the court seemed to apply was size, and even the size the court got wrong, because initially the court thought that Earth 1783 was 10 hectares. It was only about 2-point-something hectares. The point also that to me is a striking one, and that is, if that decision that was taken by the land court had been taken by a functionary, someone in the Department of Land Affairs or Rural Development, it was based on a material error of fact, because that decision was based on a misconception that Earth 142 was vacant. If that decision had been made by a functionary, it would be a nullity, because the law is clear. Justice Rogers was involved in the case of Pepkor, where a material error of fact led to the holding of a nullity of an administrative act, and that is one of the factors with respect to crying out for justice for SADA. Why should that not? Why the fact that it was made by a judge who is overreaching his powers prevents SADA from challenging the decision on the basis of illegality? And I also, again, in my preparation for today, I discovered 2 further cases, and I have informed my learned friends of these cases. But they are land court cases, and they give some guidance on how to approach the exercise by the land court of its inquisitorial powers in terms of section 32(3)(b). The first case is that of Mvolasi, the Director General, Department of Rural Development and Land Reform versus Mvolasi and others. It's a 2019 SCA case. And the facts there were different, but the same principle applies. The land court there appointed a special master to prepare reports on compensation for land tenants, and the court, the majority, led by Schippers AJ as he was at that time, described what the Land Court did there as a textbook case of judicial overreach. In paragraph 44 of the judgment, he says,
Mr.
while it is correct...
Mr. Wagner, you had the buzzer.
Have I gone? Thank you, Lords. Justices.
Thank you. You say a lot about the 2017 order. I want to hear you. Are you saying it was final in effect or not?
I think it was final in effect.
I see.
Standing is an interlocutory. Standing locus standi is interlocutory by its very nature.
Yeah.
But in these, the court made a finding that SADA's right to intervene was limited, and the effect of that was final. But my argument is that even though the effect of it was final, it was bound by the factors in which the context in which the court made that order. The context changed. The context changed in 2024 when 300 new people wanted to join in the compensation. So the context changed. So even though it was final in effect, this court, if it was final in effect, then the Land Court was bound by it. The Land Court couldn't exercise its own discretion to grant SADA standing. But this court can. And my argument is that this court is the last bastion of justice for anyone. And there flagrant injustices in this whole process to SADA and the disabled community.
I understood you to say that order was seriously prejudicial to your client.
Yes. Because it closed the doors. Land is very scarce in the Western Cape.
Well, unless you listen to why I'm raising that, you say it was prejudicial.
Yes.
Then you proceed to say there are a number of mistakes. I think you say every sentence or every paragraph
Yes.
is a mistake.
I can take the court through those mistakes.
Now, did SADA do anything about that court order?
It didn't do anything
If it
about
was
the court
soft law.
order. It's an NGO. It went along with it went along and it claimed compensation. Or it proceeded with its claim for compensation. But the game changed in 2024 when there was a new application by the intervening parties.
So
No,
that
the-
gateway that you say opened in 2024
Yes, March 2024, last year.
gives you the gateway to come here before us.
Well, the issue again was raised of the nature of the seventh respondent's entitlement.
Yes.
That issue it was a new issue, new parties, and that and where we have a judgment that, with respect, is clearly wrong
Yeah.
of this court, and circumstances arise in which this court can rectify that.
Yeah.
My respectful submission is that this court should do that.
Okay. Thank you.
Mr. Wagner,
Justice Tachiki.
what is a proper way of making sure that a court, specifically an apex court, rectifies what you say are mistakes in its previous or earlier decision?
Well, I suppose there are two ways. I mean, the first way is the court should be astute to apply the legal rules that are there to find a solution. And the legal rules that are there are those ones that I've enumerated in my argument. That if this court, and I mean, this court is not, this court's not bound by its own judgments. So where this court realizes that a mistake has occurred, this court can then look at the, so if this court isn't bound by the,
Let me rephrase my question so that we can go through this debate quicker to afford my colleagues an opportunity to engage with you as well. Do we have an attack before us? Frontal attack on the decision of the 2017?
no.
So how can we then change our flawed reasoning without that attack?
Because there's a new case before the court, a case before this court that wasn't before the court in 2017.
You see, my problem is, and perhaps this is why I'm confused by your case in this matter. You bringing a case that deals with the whole issue about the transfer of the property and who has a right and all of that. Yet, this court in paragraph 19 said that you've got an interest. It says that, but that court was in error when it overlooked the statutory right to compensation conferred on the lawful occupier, like the association, and that the transfer of the property was subject to the determination of just and equitable compensation. You accepted that. You were quite happy with that, which is why you then followed up on the claim for compensation.
Yes.
You've done that, and it could be argued that you preempted by doing that. But that's not where I am right now. I'm saying that judgment stands. It has not been disturbed or overruled or overturned. And you've agreed that there's no frontal attack as we sit here in this court to attack that judgment. So I'm now confused as to how are you here and whether you've got locus standi in this matter that we're dealing with today, because this court has already said your interest is in the compensation which you have pursued. So what other interest do you have in this matter now today?
I can only answer that by saying that the land court's decision that SADA seeks leave to appeal against of November 24 changed the entire landscape. It changed, it substituted a party who was entitled to compensation with other parties. It was a new list, a new case. So a new case arose.
Did you challenge that at the rights forum?
Well, I argued to the land court that in strict law, SADA had a real and substantial interest in that dispute. And even though this court had found in 2017 that it didn't, it was a new dispute. It was something that could be looked at afresh.
Let me just end our debate by saying that I'm getting more confused, but maybe I'll be clearer as the matter proceeds. Thank you.
Thank you.
Thank you, TCJ.
Mr. Wagner, about the substitution application, wasn't that really the basis of the substitution was merely to make clear that Mr. Sedik Sidin had always only ever prosecuted the claim on a consolidated basis for the entire family. It wasn't bringing in new parties, it was giving effect to what was said always to have been the case. And in granting the substitution, that is effectively what the court did. There was never only a claim to 1/5 of the dispossessed land. The claims were consolidated by the department in the investigative report, and Mr. Sedik Sidin always pursued it, although at times he might have denied it. he later accepted that he was only ever a representative for the family. So in substance, there was no change. That's my understanding of the basis of the substitution and also the basis on which Mr. Siddique in fact proceeded all along. Is that wrong?
With respect, it is wrong. Because the judgment of the Land Court in 2012 made it very clear that there was only one claim before it. And there was only one individual entitled to compensation, and that is the seventh respondent. The fact that he's now abandoned his rights is in fact, if anything, supports SADA's case. But one cannot ignore the fact that the Land Court's judgment in 2012 explicitly gave the land to an individual in his personal capacity.
But now the court also said in its very first 2012 decision, I'm just reading from my notes, I don't have the paragraph, after saying that there's only one descendant lodged a restitution claim representing his forebear. That was in fact incorrect. There were 4 claims. And the judge then asked, so what happens to the other 4/5? And said it is desirable, given that the whole Siddique family led a communal life on the property, that the land should be restored to all the descendants. And this is then important. SADC's counsel, Mr. Kricher, indicated that this would be in accordance with the family's wishes.
The family's wishes, but not Siddique's wishes.
Well, no, his counsel was Mr. Kricher. I think he's here today as junior to Mr. Jacobs. Mr. Siddique's counsel said that would be in accordance with the family's wishes.
But not in accordance with the seventh respondent's wishes.
Well, in what you're saying, well, I read it as indicating that SADC's counsel at that time was content and accepted that the restitution should be in favor of the whole family.
Well, that's one of the points that I make, and that is that there was a conflict of interest. And in fact, if one looks at that sentence of the judgment carefully, it doesn't say it's in accordance with Siddique's wishes. It says it's in accordance with the family, and there's a conflict between the family and Siddique, because Siddique's claim was the only one that was gazetted. He was entitled to, he had a clear right to a 1/5 undivided share of the dispossessed land. His claim was the only one that was proven in the Land Court, and that's according to the principle of legality. And that is...
Wasn't the evidence also that although it was processed under that number, whatever it was, Claim 38, by the investigator for the commission, it was done so on the basis that she, I think it was the investigator was a lady, was consolidated all the claims in her report in respect of that one claim. So it was never the Commission's intention when investigating that it was dealing with a claim to only 1/5.
That's the very point that SADA is making, that process was illegal. It's not in conformity with the Restitution Act. They had no right to do that.
Well, anyway, my concern ultimately is with whether the entire matrix changed in 2024 when the rest of the family essentially sought to come on record through family trusts and the like. At any rate, the evidence indicates that the fact that it was being pursued for the whole family was established pretty early on.
And that is, and with respect, that flies in the face of the principle of legality, because the Commission cannot decide which regime it's going to apply for compensation. It has to follow the scheme of the Act, which is by descent. There were 5 separate claims. It was never a family claim. It was never a consolidated claim. And the Commission had no legal or authority to change that scheme.
Well, that might be a contestation between members of the family and how they wish to deal with it, but let me move on. I just want to raise a legal point concerning the interpretation of Section 35. And part of this may not arise if we are not entitled to or don't revisit the Section 2017 judgment. But you read parts of Section 35(1)A and 35(1)B to us
Yeah.
about the orders that the land court can make. Now, if one looks at paragraph 1A, there are two different orders that the court can make. It can either order restoration, and then follows a whole lot of words, but can we call it the dispossessed land, the land that the claimant actually claims to be dispossessed of. The court can order the restoration of that land or a right in that land, and then it says, or the court may order any land. So there are two things that can happen. There can be a restoration of the dispossessed land, or the court can make an award of other land.
Yes.
So the court itself can award the land,
Yeah.
the other land. Paragraph B says what the land court may alternatively do is order the state to grant the claimant alternative land, and where necessary, order the state to designate it. So it appears to me that the distinction drawn, or there are two possibilities when the dispossessed land itself is not being returned. And here, apparently it was common cause that the dispossessed land couldn't be the subject of a return order. Either the court itself, because the matter has been ventilated, can itself make an order awarding other land, or, presumably when that question has not been ventilated, it may order the state to go and find and designate land. That seems to be the two different ways in which alternative land might be given to a claimant in satisfaction of his or her claim.
Now, so I just point.
So I just want to understand, do you understand the section?
Yes, no, I
Correct.
yes. No, so I just point, however, is that the section presupposes that that's an issue before the court, the alternative land.
But
In this case, it wasn't.
no, I appreciate that, but it seems to me whether the land court in making the 2013 variation, when it originally made an order for alternative land in 2012, it was ordering, it seems to be, have awarded land under A. But at any rate, when it made the 2013 variation and ordered IRV 142, it was itself making an order under 35(1)A. It wasn't ordering the state to designate the land.
No.
Now, and you'll see that, I'm sure you know this act better than I do, but restoration of land itself is a defined term in Section 1. It's clear that that phrase, restoration of land, applies to the very land of which the person was dispossessed.
Yes.
Now, if we go to Section 35(9), which is the section providing for compensation, it says, any state-owned land which is held under a lease or similar arrangement shall be deemed to be in the possession of the state for purposes of subsection 1A. Doesn't include B there. Now, if you go to 1A, you would expect to find the expression in the possession of the state, because it says, even though the land is leased, occupied under some similar arrangement, it shall still be deemed to be in the possession of the state for purposes of 1A. But when you go to 1A, you do not find the expression in possession of the state at all. And this seems to have been a sloppy piece of legislative amendment which happened in 1997, because that formulation about land being in the possession of the state actually goes back to the original form of the Restitution Act as read with the interim constitution. Because Section 35(9) in its original form, prior to the form in which we are now reading it, referred to state-owned land being deemed to be in the possession of the state for purposes of Section 123(1)A of the interim constitution. The interim constitution indeed had that expression about being in possession of the state.
Yeah.
That expression no longer exists. but it has not been taken out of subsection 9. But what is clear from the original formulation, read with the interim constitution, was that that provision about being in possession of the state applied only to restoration of the dispossessed land.
That's how I read it.
And I think it's despite the clumsiness of the language not having been cleared up, if you read the proviso, provided that if the court orders the restoration of a right in such land, the lawful occupier shall be entitled to compensation. Now it says if the court orders the restoration of a right, that can only relate to an order
In terms of section 1.
the dispossessed land
Yes.
back to the claimant.
Yes, that's my point.
So on the face of it, this court in 2017 seems to have proceeded on the assumption that this section applied also to alternative land.
Yes. And it doesn't.
Prima facie, and one or more of the counsel for the respondents may address this, because I would have a similar question for them. It seems on the face of it that this court may have erred in treating section 35(9) as being applicable to alternative land.
That's my respectful submission.
The question is what then becomes of it? I'm now not saying whether we can reopen the 2017 judgment, because the whole point of res judicata is that whether the judgment is right or wrong on the law, it binds the parties to the case. That's how res judicata works. In a different case, the court might say it was wrong, but it might be bound by res judicata to stand by its 2017 judgment. But just following the question of interpretation through, it seems to me that what was in mind is that there's a very strong desire, given the whole purpose of land restitution, that where it is feasible to restore the very land, the dispossessed land, back to the claimant, in order to balance the interests of the claimant as against a current lawful occupier, the current lawful occupier may have to be content with compensation.
Yes.
And will lose the land.
Yes.
Where, however, one gets to the position of alternative land, one is no longer achieving the primary purpose of the Restitution Act, which is to give the very dispossessed land back.
Yes.
You have to find something else. Now, in the process of finding something else, it may be that you shouldn't go and find something else which is lawfully occupied
Yes.
by a third party.
That's the point.
You've got to find something that
Yes,
isn't
it's
so.
not occupied.
Or, if you go back to subsection 1A, to award any land, it envisages that in order to achieve that, the state may acquire the other land or may expropriate it. Now, obviously, if you were bought out of your lease, well, then you would have agreed to some compensation. If there's expropriation, there would be expropriation under the compensation under the expropriation legislation.
Yeah.
But absent one of those two things, on the face of it, it appears to me that this legislation means that alternative land which is lawfully occupied and which has not been bought out or expropriated cannot be awarded, because there's no mechanism for compensation, because subsection 9 doesn't apply to alternative land, only to the dispossessed land.
Yes.
Rightly or wrongly, this court in 2017 said that subsection 9 did apply. So if that is raised judicata already to claim compensation, and none of the respondents in this case contest your right to go ahead and claim compensation. So on the face of it, that equitable remedy is available to you here, whether legally it should have happened or not. Now, why isn't that sufficient?
Well, it's because SADA has had a month-to-month. The right's worth nothing. SADA is not entitled to any compensation. It had no legal. There's no basis on which to or measure in which to compensate SADA. The SADA is interested in the land, not in compensation.
Do you say that if, I'm not sure who, the land apparently is under the control of the National Department, but doesn't seem to want the rent. But either way, I'm not sure if the rent's still going into the trust account. But either way, if it's a month-to-month lease, either the national government or the provincial government could give you 1 month's notice.
Yes.
And then the land could be granted to the land claimants.
Yeah, they'll be into the matter.
But then why wouldn't it be available for award? Isn't that, has the lease been terminated?
The lease has never been terminated. What happened was, it's in the papers, the original lease was between the Western Cape government and SADA, and it came to an end in 2000. From 2000 to 2007, there were annual written leases. After 2007, a letter was written by the representative of the Western Cape government saying the lease will continue on a monthly basis until further arrangements are made. So that's where we are today.
So obviously it's not for the land court or the regional commissioner to terminate the lease. They don't have that power.
No.
So although you might be precarious, you say as a fact that neither the provincial government nor the national government has terminated your lease.
No.
Therefore, currently you are a lawful occupier of the premises.
Yes.
And unless one of those public authorities chooses to terminate the lease despite the good work your organization, your client's organization does, you will continue to be a lawful occupier.
Yes.
But your complaint is that if you are confined to a claim for compensation, it may be,
Worthless.
well, you may still be entitled to the improvements. We don't have, do we, the answer? Who opposes the compensation claim?
State opposes the compensation.
Is that the state through a national department or through the regional commissioner?
The regional commissioner, the Department of Public Works was joined as a party in the compensation proceedings.
And this may not be before us, but based on what the national department has said in response to the claim, what in essence does it say?
It says SADA is not a lawful occupier, and it can take the value of the cost of the improvements in terms of the lease.
Does it
Which is
say
negligible.
the lease has come to an end? Why?
Yeah.
If they are the owner of the land and you have a month-to-month lease, if they are saying you are not a lawful occupier, are they not in essence saying that they've terminated your month-to-month lease?
Well, I suppose it's implied, but they've never given us notice to that effect.
So if the owner, if you accept that the owner of the land is the national department and the national department can terminate your lease, and they are acting as if they have, then however unfortunate it is for your client, you may be left with the position that at most you can recover the costs of improvement.
Yeah.
Now, but why would that be different? Assuming if we wound back the clock and the national department had said that back in 2013, then there couldn't be a difficulty, because then you wouldn't have been a lawful occupier.
Yeah.
But it's come to light now in the context of a compensation claim.
Yeah.
It seems to me all a bit of a mess,
Yeah.
and I can understand why your client feels hard done by. But if you accept that you are in a precarious position and the owner of the land is treating you, has de facto terminated your month-to-month lease, aren't you in substance then of, why would us intervening change the circumstances? Because whatever we say, if the national department now considers you to be an unlawful occupier, we are going to be deciding the case on in a sense, an artificial basis. We'll say, well, the land court shouldn't have done what it did in 2013 because then your lease hadn't been terminated and you were a lawful occupier then. But we know time has moved on, and apparently you might no longer be a lawful occupier.
Well, the background to that question is that the authorities, in fact, are in favor of SADA staying on this land. And you'll recall in the beginning, I made reference to the undertaking by Carlisle to give us a 50-year lease.
I can understand the provincial government certainly has expressed that view, but why is the national government now taking the attitude they do?
Well, you'll see from the papers that Mr. Carlyle said that he was going to take steps to have the properties that were registered in national government retransferred to Western Cape because they were originally did belong to the Western Cape. And that has partially been completed in terms with regard to Earth 141, which is a smaller piece of property but significant in size. It's 1.29 hectares. So 141, at the time of this case before the Land Court, 141, 142 and the two top ones, the two small properties at the top, all were, in terms of a single lease, they were all consolidated for the purposes of a single lease, and SADA was the tenant. And that was the lease that was renewed on a yearly basis. But what Carlyle said is he was going to get the properties transferred back to Western Cape so that he could give SADA a lease of 50 years. And that's why it's so important to SADA to be involved in the selection of the alternative land, because we know that there are two other properties that in fact are vacant that were in the mix. And SADA would be able, with respect, would be able to argue before any functionary that makes that decision of alternatives, because the state has to select the alternative land, not the court.
Now, this court in 2017, and I ask this knowing that you have criticisms of how the court went about it in 2017 and your criticisms of the process and resultant errors you say the court made. But this court in 2017 found that you didn't have an interest in whether the land was awarded or not, only in getting compensation. So the argument you advance about having an interest, that hasn't been changed by the substitution in 2024. It's always been either a tenant in your position does have a legal interest in whether the state-owned land is awarded to a land claimant or it doesn't. And that would be so whether the claimant was SEDIC or whether the claimant was the whole family. And this court in 2017 said rightly or wrongly that you didn't have that interest. That was the point on which it took submissions, and it decided that point against you.
Yeah. Now, my respectful submission is that you cannot separate the right from the remedy. So when you re-examine the right and you identify the fact that there's only a 1/5 claim before you, then the question of the remedy must come in. What's the size of land that you must be given in restoration?
Well, that goes back to what we debated initially about who the claim was really on behalf. I don't want to go down that path again. What might be a different answer that somebody in your position might give would be that this court assumed or found that SADA did not have an interest in whether the land was awarded because it took for granted that SADA would have a right to compensation if the land was awarded.
Yeah.
Now, if this court had found, if that point had been argued, and this court had found that 35(9) didn't apply to alternative state land, it might have said, well, you could have no right of compensation. It must then have a right to be heard on whether the land is awarded or not.
Yeah. That's the whole point.
The difficulty is that you brought the application in this court on the footing that 35(9) did apply. It was in the rescission application in the land claims court against which you were appealing to this court. You quoted the passage from the founding affidavit in the land claims court in which you said 35(9) applied. And while I appreciate that in your written submissions in this court you said, in this court you came to the view that that was wrong, that's not in your submissions. It wasn't abandoned. I mean, it wasn't the point that was on which submissions were requested. But so on the material before this court in 2017, it was your own case that 35(9) applied.
On the material before the court, that was an allegation in the founding papers. It is so, yes.
Would you say if you had been heard, you might have abandoned?
And also in the written submissions, I referred to the leading cases of Bullock and Grays Marine, all those cases.
Yes. Thank you.
Wagner, just, my colleague has dealt with res judicata. Now, I'm going to move on to something else. You've criticized this judgment of the 2017 court. You haven't applied for rescission if you say it's clearly wrong or there's a patent errors of law.
Yes.
So, what are we to make of it? I in with my next question, which deals with preemption.
Well, I can only give the answer that I've been giving all the time, and that is that the right to a 1/5 portion is linked to what property should be given. So those two issues were relitigated in 2014.
You're not answering the questions. Why haven't you applied for rescission of that judgment if it's so patently wrong?
With knowing what I know now, I'd apply for rescission.
See, that's not good enough, but let's move on. Because then what you do is you proceed to seek compensation, A, and B, you engage with the other parties in a mediation process. Now, in anybody's language who understands a little bit about the law, that is an unequivocal waiver of any right you may have had to an appeal, but you can't appeal because it's the apex court, or a rescission, isn't it?
If it turns on whether a rescission is the only answer, but I can only counter that, Justice Majid, by saying that in the exploration of this difficult and complex dispute, it's discovered in argument that this court made a material error of law, and this court, as the last bastion of justice, has the opportunity to rectify that. The court should be astute to do so. And again, the argument is that to me, the cardinal issue is the nature of the right that we're dealing with, the 1/5 right. And that issue came up again in 2024 with different parties. And that's why res judicata doesn't apply, because they're different parties. There was only one. The party that was before the court in 2017 was Sadiq Sadin, the 7th respondent. The 300 family members weren't party to, in law, were not party to that claim.
We are not at res judicata. We are past that point. Anyway, let me move on. Time waits for nobody. You see, you made a statement earlier that I'm not sure whether I heard you correctly. You said that this court is bound by its own decisions. This court has on numerous occasions overruled previous decisions as long as the court is satisfied that they are clearly wrong. Now, of course, this is the same case, so what you had to do was to apply for rescission, but you haven't. I just want to correct that statement. This court is bound by its own decisions, but it can overrule them if it's clearly wrong. But I want to ask you this, or I want to say this at the end. Your client, plainly on the facts here before us, do very good work. For that it is commended. But here we have a family who's been dispossessed of land. Now, Mr. Wagner, land is a very emotive issue. Those of us who have been moved off land, have never been dispossessed, but those of us who have been moved off land, you grow an attachment to that land. It's a very emotive issue. This Sadin family has been waiting for many, many years to get their land restored. And it's time that this case gets finalized. We can't keep on coming back. That's all I want to say.
Thank you, Mr. Wagner. I just want to pick up on the last point and maybe start there, because you started by correctly pointing out the vulnerability of people with disabilities, and I associate myself with that. But at the same time, the genesis of the Restitution Act lies deeply engraved in our past and in our tragic history. So much so that, and I didn't hear you speak about that, in the context that apartheid itself was declared a crime against humanity. And this legislation is sourced in the Constitution in section 25(7), which recognizes the need to address these historical injustices. And indeed, in the judgment of this court, in the Salem case, and I'll give you the case reference, it's Salem Party Club and others versus the Salem community, and the neutral citation is 2017, /ZACC 46, where this court said that history's gross injustices underlies every single provision in the statute. And so that's the recognition. But in that case, the court also embraced the notion that the provisions of the Act have to be generously interpreted, and that the courts should lean liberally towards the realization of the objectives of the Act. So that's the location of this piece of legislation in any kind of dispute. But what I hear you arguing is the rights of SADA, important as they are, must now be considered on the same footing as the rights of those who were dispossessed. If that's correct, that can't be right.
With respect, Justice Colopin, what I'm trying to say is that I'm not disputing for a second that the Sardine family has rights, but the remedies are clearly defined in terms of the Restitution Act, and there are limits beyond which one cannot go, and there are remedies. What SADA wants is the right to be heard. SADA is not saying no land to the Sardines. It's saying we want to be heard with respect to this specific piece of land.
Sure. Now let me just get to that. So if the Restitution Act assigns to the state this formidable task of effecting land restitution in a manner that's constitutionally compliant, and included in that is the obligation of the state to use state-owned land, where land that has been dispossessed cannot be restored. And that's the reality of our time, because the Act is dealing with events from 1913 onwards. And so it's a long time, it's more than 100 years. And in truth and reality, a lot of the land that has been dispossessed will not be capable of being restored. And therefore, the use of state-owned land would have to be. Now, I have a difficulty with this proposition that where the state owns this land and someone is in occupation, the occupant may have a legal right to have input into how that land is allocated for the purposes of a constitutionally compliant and a constitutional imperative. The question of compensation is a separate one. But with the argument that every occupant has a right to be heard when the state makes a determination with regard to the allocation of that land for the purpose of the Act, not unduly limit the ability of the state to, in fact, give effect to its objectives, but also would have the effect of elevating, as it were, almost the rights of the occupants to the rights of claimants. And so, and I've listened carefully to the debate between yourself and my colleague Justice Rogers, but I'm just concerned that we interpret the Act and the rights of the various competing parties, and here the competing parties are really SADA and the family, in a way that recognizes, as it were, how this debate fits into the broader framework of the Constitution, and in a sense, the hierarchy that it creates, because it does create a hierarchy.
Justice Colopin, my answer to that is that the you can have a win-win situation here. What SADA wants is the right that SADA complains has been infringed is the right to be heard. Now, if we have, when we are talking about alternative state land, and we have two properties with exactly the same size, dimensions, suitability, all those things, and the one is occupied and the other one isn't, my argument is, why can't SADA be heard to say, we've been on this land for 30 years. We're not saying you mustn't give alternative state land. We're saying there's a better option to be exercised in the selection of alternative land. We're not saying alternative land shouldn't be given or chosen. We're just saying that selection process is essentially an administrative law process that is carried out by the state in these. The Act envisages that the state will designate the land. And the state, when the state, I referred to it in my written argument, this question was ventilated to some extent because the land, the developers, they asked the question in the land court, why isn't alternative state land considered? And they mentioned Earth 142, they mentioned Earth 3110, and they mentioned Earth 1783. And if you see in those further particulars, there's a committee, a land claims committee, that investigates the suitability of these particular pieces of land. And the answer they gave why they didn't consider Earth 142 was competing interests. So it's simply, SADA simply wants to be involved in that process. That's all SADA wants. And so it's not a question of depriving anyone of their rights. It's simply a question of, they both have rights, but both have to be orderly disposed of in terms of the legislation.
You've heard my view on that, my prima facie view at least, but this court had disposed of that argument quite compellingly and in unambiguous terms, that SADA's rights are confined to the right to compensation, not so.
I accept that.
Sure, and you've dealt with the question of why that order was not rescinded, why there was not an application for rescission in response to my other colleagues' questions. Okay, thank you, Mr. Wake.
Thank you. I have it, Justice. Sorry, I've only got the first part of Rule 20. It's going to take me some time to find it on my machine. Can I ask the court to read it out to me?
Mr. Wagner, we will take the 15-minute tier judgment. Hopefully by the time we come back, you will have, in fact, it's 20 minutes, not 15 minutes. 20 minutes tier judgment.
Apologies.
Mr. Wagner, hopefully you found the part you were asked to read out.
I actually did. I had it all the time, Deputy Chief Justice.
Please go ahead. Please go ahead.
The Chief Justice may decide whether the appeal shall be dealt with on the applications for leave to appeal, as the commentators in Erasmus say, it's fine, but when it comes to actual appeals, A, you should have a record, and B, you should be given an opportunity to present oral argument.
So is the submission that that rule is unconstitutional?
It's not, I'm not saying it's unconstitutional, I'm just saying that, as they say, as the commentators say, the discretion should be exercised sparingly. So there will be some situations where oral argument probably wouldn't make any difference. Or given the
And what is the applicant's submission in this matter? Is the submission that the discretion which the Chief Justice has under Rule 20, Sub-Rule 5, should not have been exercised? And is that a matter that the applicant is raising in this matter?
well, it's certainly a matter that I'm raising, Justice.
Where has it been raised on the papers, Mr.
It hasn't been raised on the papers, but it's raised on the basis that Section 38 of the Constitution says that where constitutional rights have been infringed, that the court should be, that some remedy should be found.
Where has this been raised as an issue in this matter to alert the respondents to that they must respond to it, to alert the court as well that this is an issue that the court will be called upon to decide?
I concede that it's not, it hasn't been raised.
So then it's not before us, is that right? You accept that?
I accept that it's not before you, know.
Yes. Mr. Wagner, what does the applicant rely on for this court's jurisdiction?
The direct access.
What is the constitutional issue that this court must decide, or what is the Section 35(9)?
35(9), Section 2(1).
And that was interpreted in this court's 2017 judgment. Where the court interpreted that, and the court concluded that the applicant's right is limited to a claim for compensation. The court interpreted that question in this matter.
And my submission, respectful submission, is that that finding was bound by its context, and the context changed.
Yes. My question is, Section 35(9) was interpreted by this court in its 2017 judgment.
Yes.
So
So we don't need another interpretation. So that if it's already been interpreted by this court, then that doesn't give the applicant access, or the applicant can't rely on that for constitutional jurisdiction.
My submission is that if that issue arises indirectly, that it remains.
Basis for this court to, or not to accept that judgment in 2017. What standing does the applicant have in this matter?
The standing that the applicant has in, if one looks at the facts, it had a
Let me try to simplify my question. If we accept on the basis of this court's judgment in 2017 that the applicant's rights is limited to compensation, what standing does the applicant have in this matter or any other matter relating to